We are going to start with the three threats to your legacy because understanding these threats will help you create a living trust that will counter those threats. We will go through the 4 steps to create a living trust. And what are the modern options these days of creating a living trust? I will also make sure we have time for Q&A. Okay, so that's our agenda for tonight. How to finally get your estate plan done. A lot of us spend many years working hard building this legacy, this beautiful cake for our children, our beneficiaries, not realizing that there are many unwanted guests with forks in hand waiting to take a slice of our beautiful cake. If we don't plan properly, by the time it gets to our kids, maybe a big chunk is missing, or only a slice is left. By the time it gets to the grandchildren, maybe just crumbs. So tonight, one of my goals is to help you see how you can keep your legacy as intact as possible for your children and your beneficiaries. Okay? Who is trying to take big bites of your cake anyway? That's what I refer to as the 3 big threats. Okay. First, let me introduce my mother-in-law, Alice. She was either showing off her manicure or doing the Queen's Wave. I'm not sure. We all love her. Unfortunately, we lost her during the pandemic. And my husband and I, we live in Boston. We had to fly to Texas for the memorial service. It was very beautiful. And my husband, as the executor, thought, while we're there, we're going to wrap up the affairs because my mother-in-law had a will, but she didn't have a trust. So the first surprise that my husband, her eldest son, encountered was that just because you have a will doesn't mean that it instantly works. A will has to be approved by the court, and he cannot be the official executor until the court blesses it, which took about 3 weeks. In the meantime, the assets were frozen, and the siblings had to negotiate who will pay for the memorial service, the probate attorney, because they had to open probate. And one child was still living in the house and would not cooperate leaving the house. And there was nothing the other siblings could do because the executorship was not official yet, so no authority. She also left 2 pages of personal items, this handmade quilts going to this grandchild, this special, set of china is going to a daughter, and so on and so on. And normally that would be, not a problem. The family would get together and divvy up the things. But because it involves probate, a judge, a court, everything had to be recorded, which was the job of the executor. So my husband was just really complaining about how painful it was to record what items were actually already missing, what items went to which kid, and what items were declined, and all that. When you involve the court and the judge, the record keeping just takes on a whole new level. The house also missed, if you remember, during COVID, there was a time where houses were really selling at peak values. But because of all these issues, they missed that time. Not to mention, it took several trips for my husband to go to Texas to wrap everything up. And we realized when we talked to friends that we were the only people, suffering with this probate. In fact, a recent article in Forbes said that not only is probate a big emotional toll on the family, on average, this is actually the number provided by AARP, the average probate takes 20 months to wrap up. And all that time, the assets are frozen and you can't have peace from the your loved one leaving. And it also costs 3 to 7% on average. So let's put a number to that. Okay, let's say my estate is a round number, $1 million, and everything went smoothly. No family disputes, no surprises, all the assets were accounted for. And so my probate came in at the low end, 3%. 3% of $1 million is still $30,000. That's money that should go to the surviving spouse or to the grandchild for tuition, not to the probate court. In America, there are two ways you can pass your assets on to your children. Okay. The first is through a public court control process called probate. The second is a private family contract, also known as a living trust. The first way is done in court. The second way is done in private. It could even be in mom's living room, mom's kitchen. So, one of the things you should walk away with from this webinar is making sure you know which way you're leaving your assets to your children, because they're very different. And I'm sure you have a preference to do it the second way, not the first way. And I'll explain how you will know whether you're going the first way or the second way. So that's threat number one, the delay, stress, and costs of probate. Threat number two is even more costly, if you can imagine it. Let's see if you'll agree with me, but after I explain threat number two, okay? Threat number two is family fracture. So let's talk about family fracture, okay? You've heard of families who inherit, money from their parents, a good thing, right? And then suddenly you hear that they're not talking to each other, they're suing each other, and you say, oh, that's too bad. But the same thing can happen to our kids, to our descendants, if we don't plan properly, if we don't understand the causes of family fracture. So let me go through the causes of family fracture. The first is probate. Probate is super stressful, and then it also delays, and folks have to upfront money. It's also public. You have in-laws whispering things like, oh, you took so much time off to be with your mom, or oh, you financed that kitchen renovation, you should get more. I would say something if I were you, that kind of thing. But the reason probate causes more family fracture than if you had a living trust is because probate is a court process. It's a ready-made venue for disputes. The judge is already there. The attorneys are lined up. A complaint system is already built in. All it takes is one confused or unhappy, beneficiary, and it can escalate from there. So family fracture is one of the big causes is probate. The second cause of family fracture surprised most people. It's the family home. Don't think of the family home as just another asset. The family home is a very emotional asset. It's Christmas mornings with mom, it's baking cookies in the kitchen. It has very emotional ties for everyone around. It's also unequal, right? Maybe one sibling took a lower paying job to live closer to mom. Maybe, like I said, one sibling paid for the kitchen renovation, or one sibling took care of mom's health care. So it's hard to put a price, a value on those things. And it's also illiquid. You can't, divide a house in the middle. The third cause of family fracture is surprises, hidden accounts, or unexpected debts. That's not what mom told me. Parents telling different things to different kids, or last minute changes, unequal gifts without explanation. So these three things can cause a family to fall apart, which I think is the saddest cause of not having a plan. Okay. If my husband and I pass away and we find out that our children, instead of enjoying their inheritance, their legacy, they're fighting, they're suing each other, that would kill us a second time. So that's threat number two, family fracture. What do you think threat number 3 is? We have threat number 1, probate, because it's so costly and stressful. Threat number 2 is family fracture. A lot of people think threat number 3 is death taxes. Is it? Let's just quickly review death taxes to make sure we're on the same page, okay? So first you have the estate tax. That's the tax on the person who passed away. Of course, he's not around to sign a check, so it's taken out of the estate. That's why it's called the estate tax. It's very high, 40%, but fortunately, the government is only after the big whales. You have to have more than $15 million a person. That went up this year to $15 million a person. A couple, that would be $30 million. So it's probably not going to hit most of us. The second tax is the inheritance tax. That's the tax on the children or the beneficiary receiving the inheritance. Good news, in the US, it's zero. So if you get a call tomorrow saying an uncle you never heard of passed away and left you $1 million, your responsibility, your inheritance tax would be zero. Then there's the capital gains tax. I've lived in my house for 30 plus years. If I sell my house the day before I pass away, I would be paying a huge capital gains tax because my house has appreciated a lot over 30 plus years. The government wants a piece of that appreciation. That's called capital gains tax. I'll be paying quite a good sum. But if I pass away and my house goes to my children, they could sell it the next day, the day after I pass away, and they will pay zero capital gains tax because of the step up in cost basis. So that's another good news on the tax front. Now remember, our taxes have a federal level and the state level. So what is it like at the state level? Well, for the estate tax, only 13 states in the US impose an estate tax, and they're not high like 40%, they're a lot lower. On the inheritance tax, most states now don't charge an inheritance tax. And especially if the beneficiaries are the children, the inheritance tax is waived if it's the children, except for 2 states, Pennsylvania and Nebraska. Capital gains tax at the state level, it also steps up. So let's see how this plays out with my friend Mike. Okay, I've changed his name and I've rounded off the numbers, so he's okay with me sharing. But he got quite a sizable inheritance from his dad. His dad's home was worth 1.2 million, more than double what he paid. There was an IRA, a Roth IRA. His dad also left him a life insurance policy and a rental property and some brokerage accounts, stocks that have also appreciated a lot. All in all, $4.5 million in inheritance. Excuse me. But Mike's first thought wasn't, hooray, I struck the lottery. His first thought was, I'm going to be hammered with taxes. So let's calculate Mike's tax bill, okay? Let's start with the federal. Well, the estate tax at the federal level has an exemption of $15 million. Mike's inheritance isn't even a third of that, so zero federal estate tax. Inheritance tax, they live in Florida, not one of the 13 states. Oh, sorry, this is federal. The US has no inheritance tax, and capital gain steps up. What about the state, Florida? Estate tax in Florida doesn't exist. Inheritance tax doesn't exist. Why do you think so many people retire in Florida, right? Capital gains tax also step up. So $4.5 million in inheritance, and his tax bill is zero. Now, not all of you live in Florida. What if you live in my state, Massachusetts, also known as Texachusetts? So let's look at Massachusetts. We have an estate tax. Anything above $2 million for one person is taxed at 8%. Okay, so now let's look at what Mike's tax will be if he lives in Texachusetts. So it's $2 million per person for his dad, and then another 2 million for his mom. So that's 4 million exempt. So what he has to pay estate tax on is $520,000. 8% of that is about 40. I'm being covered here. Oops. It's about $40,000. So that's only about like 1% of this entire amount, 4.5 million. Let's in case you're worried if your state also has these taxes, let me go through the states that impose a state estate tax. So like I said, there are 13 of them, but only the ones that are highlighted yellow have an exemption that's under 3 million. The others have exemptions of above 3 million. So if you're passing down less than $3 million, it would be exempt. You don't have to worry about it. Only 5 states have an exemption of under 3 million. Oregon is pretty bad. 1 million, anything above 1 million will have an estate tax. But look at this list. It's really just five states out of the 50 states in the US. So death taxes is not something that most people need to worry about. So threat number 3 is not death taxes. Threat number 3 is inheritance erosion. Here's what I mean, okay? Say your entire estate bypass probate and your family is preserved. Everyone is still having Thanksgiving together. Everyone still talks to each other. Great. It dodged probate, it dodged family fracture. Now it made it intact to the children. Guess what? A new set of risks show up. Let me go through them, okay? That's what I mean by inheritance erosion. Dangers to our heirs' inheritance. First is the lottery winner's curse. Have you heard that lottery winners actually lose their lottery winnings? A lot of them lose their lottery winnings in a few years, and some are even worse off because too much money too quickly without guardrails just make people do stupid things. The same thing can happen to our beneficiaries if we don't educate them, if we don't prepare them, if we don't plan to protect them. That's a lottery winner's curse. Oops. Sorry, this is not in order. Are your kids in high-risk professions like a surgeon or a business owner? If they get sued or they get involved in liability, loss, professional liability, their inheritance, if they own it outright, can also be exposed. Divorce. Inheritance is actually considered separate property. It's not considered marital property. The problem is that after decades of a marriage, it's very easy to get it commingled. Here's an example that I hear all the time, okay? So say I pass away and my kids get an inheritance and she knows enough to not get it commingled. She puts it in her own name, in her own bank account. And then, after a number of years, money is tight one month. And she thinks, oh, my money's just sitting there in this account. I'm going to use it to help pay the mortgage for this month. Very nice thing, right? So if she does that enough times, at the event of a divorce, her spouse's attorney could claim that that inheritance has been transmuted into marital property because it was used to support a marital asset, the house. And in a situation like that, half her inheritance could walk out with the ex-spouse. So it is quite a responsibility owning, a big sum of money. I put this bullet here, heirs passing away early, when I heard this story of this young man who inherited quite a sizable inheritance from his parents when they passed away. But before this young man set up his own estate plan, he got into a car accident and he passed away. What do you think happened to his inheritance? According to the court, it should go to the next of kin, which was his wife. A couple years later, his wife remarried, started her own family. So essentially, this young man's inheritance totally left the bloodline. So these are the dangers to our heirs' inheritance that could erode what we pass on to them. Here is a study, it's a 20-year study of over 3,000 families that shows that by the second generation, only 30% of the inheritance is left. And by the third generation, only 10%. So when I use this metaphor of the cake to slice into crumbs, I really wasn't exaggerating. And the reason this happens is because lack of planning. So you've got probate or family disputes, family fracture, and beneficiaries squandering the money or getting it lost in divorce and so on. So, if I were to tell you that there's one simple thing you could do to protect yourself against these three threats, would you do it? I I think I can guess the answer. That one thing, I'm sure you guess it too, is a living trust. But don't just take my word for it. In the next few slides, I'm going to explain how a living trust does that, how a living trust protects you against those three threats that we went through, okay? A living trust protects you against probate, but how? It keeps the family whole. How? It preserves your children's inheritance. How? That's what we'll be covering the next few slides. So let's talk about probate because this is really important to help you understand if you're going to end up in probate or with the second method, which is a private family contract done in the privacy of your own home. First, you need to understand what triggers probate. Very simply, probate is triggered when we die with assets in our name because we're no longer around to sign off on the title of these assets. In this country, it's a big deal when you transfer a property, a house, from a seller to the buyer. If you've bought or sold your house, you remember it's a very serious room with attorneys and brokers and signing off gazillion papers and initializing them and notarizing them, etc., because it's a big deal. But if you're not around and your assets are still in your name, then who's going to sign off on those assets? So the court has to step in to make sure that those assets transfer to the right heirs. I know probate gets a bad rep, but the intention is actually good. It's to protect us, protect our assets, and protect our beneficiaries. How does a living trust avoid that? Well, a living trust protects you from probate because it becomes like a proxy. Some people call it a treasure chest, some people call it a luggage, a suitcase. The idea is that you transfer your assets into this revocable living trust, so you're no longer the owner. Then, when you pass away, the court doesn't need to step in and supervise a proper transfer of your asset because your assets are not even yours anymore. They're owned by the living trust. You are not the owner, but you're still the trustee, meaning you have full control of your trust. You could refinance your house, you could rent out your house, you could sell your house, you can buy new stocks, you can dissolve your brokerage account. In fact, you could even dissolve the entire living trust if you wanted to. So you're not the owner, but you still have full control. That's how a trust protects you from probate. How does the trust reduce family fracture? Well, by avoiding probate and by encouraging intentional planning, the process of creating a trust itself just helps you to anticipate issues, to plan things out, to talk to more people and get feedback. So, in that way, it reduces confusion and surprises, which is a big cause of family fracture. And finally, how does a trust protect the inheritance from being squandered away? Well, a trust allows you to specify distribution ages. You can say they get a quarter at age 30 and they get the rest at age 40. It allows them to mature a bit more in the school of hard knocks. And another way is by appointing a trustee to manage the inheritance if you feel that your children aren't ready to get the inheritance. A trustee can make sure that your rules are enforced to protect the inheritance. I want to explain that a lot of people think, oh, that's so restrictive. That means my kids can't, enjoy their inheritance until they're age 30 or age 40. The IRS has a rule called the HAM standard, and it says that before they reach those ages, if they have, and in estate planning, you'll hear this phrase a lot, HAM standard, if any of the beneficiaries have needs that are related to health, that's the H, education, that's the E, maintenance or support, they can access their inheritance even before they reach those ages. So example, if one of my children has a medical condition that needs a lot of financial support, that's health. She'll be able to access the trust even before she reaches the distribution age. Or if your kids want to do a master's program, a PhD program, or if they lose their job and they just need some financial support to tie them over. So I really like this because the inheritance is protected until they're ready. But if ever they are in this situation where they have this need, they can still access the funds. So that's how a trust also safeguards the inheritance from erosion, inheritance erosion. All right. Now we're going to the section on 4 steps to create a living trust, but I've covered so much already. How's everybody doing? Good? Keeping up? I know you follow my videos, so a lot of this is not new to you. I think you should give yourself a pat in the back that your estate planning knowledge has grown. Okay, now we're going to the section on the 4 steps to create a living trust, because this intimidates a lot of people. They hear that, oh, this is an attorney job. I can't do this. A lot is at stake. So let me help you to think about this process. Think about it as think about building your house. Okay, 4 steps to building your house. First is planning, the big picture, the key decisions. Do you want 3 bedrooms, 4 bedrooms? Do you want an open kitchen layout? Second is recruiting a team to build this house. And then third is making sure that you've got the right inspections to the house to make sure it's ready to be moved in. And fourth is actually finally moving into the house, right? You may wonder, like, why would of course people build a house to move into. Why is that even a step? Because you'll be amazed how many people spend money and time creating a living trust, and then they don't transfer their assets into the trust. So they die with assets still in their name. You know what happens? Probate. That's not the trust's fault. The trust is there. You need to transfer assets into the trust for its protection, for their protection. So let's drill down into what each of these steps means for a living trust. So what are some key decisions you want to make? Okay, if you're married, you want to decide if you're doing a joint trust or an individual trust. It's not that obvious. Just because you have children from previous marriages doesn't mean you should do separate individual trusts, because you may have had that second marriage for a while and you treat all the children equally. And just because it's your first marriage and all the children are from that marriage doesn't mean you should do a joint trust. Another key decision is the distribution of assets, right? Who is getting what? When? And do you want a trustee, an uncle, or perhaps your daughter is an accountant. She could be her own trustee, or perhaps you want a commercial trustee. So these are some key decisions that you want to think about before you even get online or talk to an attorney. Key successor roles. These are the 4 successor roles that are very important people. They'll be running the show when we're incapacitated. The healthcare proxy. This person will speak about our healthcare needs and preferences. The power of attorney, our finances. Otherwise, it's frozen and we can't pay the mortgage. We can't cash checks. And the guardian, if you have children under 18, and successor trustee will make sure that your rules in your trust are followed. Now let's talk about step 2. That's creating your plan documents. whether you're working with an attorney or you're working on a online platform, the same applies. If you're working with an attorney, make sure that this attorney is a dedicated estate plan attorney that does only trust and will, not an attorney that does business contracts, divorce settlements, and estate planning on the side. Okay, dedicated purpose. Next, you want to make sure if it's a platform that is easy to use yet flexible and powerful. Same thing when working with an attorney. You want to make sure it's an attorney who speaks English. If he can explain things to you, that's on him. I mean, you're paying him to make things clear for you. And finally, make sure that the platform is just as like for an attorney, that it's tailored to your state, right? You can only work with attorneys licensed in your state. You want to make sure your platform is state specific, that it can handle your state's unique requirements. You also want to make sure that you get the right support and guidance, because my guess is for a lot of you, this is your first time doing this. Chat and email, a lot of platforms offer that, but you want to make sure it also offers phone support. It's so much better when you can pick up the phone and call someone and ask questions. Resources, checklists, step-by-step worksheets, those are important. But the third one is something that is quite rare. It's attorney support. A lot of people just feel better when they can have an attorney to review their plan and give them a thumbs up, or if they have some unique situation, they need some legal advice, they have an attorney to call. The third step is making sure the documents are validated. There are three things to bear in mind: signing it, witnesses, and notary public. And not all documents require all three. Amazingly, for most states, you only need witnesses for the pour-over will, not the living trusts. But the living trust needs to be notarized and signed. So you want a platform that gives you very clear instructions, and you want to make sure you follow them religiously. When you talk about do-it-yourself plans, one of the most common reason it fails is because it wasn't signed or it wasn't notarized per your state's specific requirements. So this is a very important step not to take lightly. And finally, you have the last step, which is funding the trust. Okay, that's transferring title of your assets into the trust. So now when I die, I'm no longer the owner, and the trust is the owner, and the trust can just follow the instructions. I want to make two things clear about having a living trust. One is that even though, and I've alluded to this, but it bears repeating, even though you're not the owner, you're the trustee, you still have full control of your trust. Okay, that's one thing to remember. And in fact, the revocable living trust does not file its own tax return. All the taxes are still filed by the grantor, who's also the trustee, who's also the beneficiary while he's alive. Another thing I want to make sure you understand about revocable living trust is that not all assets belong to the trust. An IRA, for example, don't change title into the trust, because if you do that, the IRS considers that a withdrawal. And if you're not 59 and a half yet, you might get all kinds of penalties. But even if you are, you'll have to pay withdrawal taxes on IRAs. So IRAs and 401ks do not belong to the trust. You can make the trust a beneficiary of the IRA, but it doesn't own the IRA. Life insurance also should not be transferred into a trust. The trust can be a beneficiary, but if you make the trust the owner, it gets complicated unnecessarily. Cars, it's controversial. Some attorneys say, yes, it should belong into a trust. Some say don't. I'm on the side that says it shouldn't be put in the trust, because if you're ever in an accident and the other party finds out the car belongs to a trust, they just think, oh, deep pockets, and then they sue you. Besides, it's so easy. A lot of cities have at the registry of motor vehicle, they provide an easy way for cars to be transferred to another person when the owner dies. So since it's easy to do that, you don't end up in probate, why take the risk? These are personal items, special. expensive, sentimental, valuable items. They don't belong in a trust if you think you're going to sell them or change them or they're not very valuable. Either I say give them away and see the smiles of the people you give them to, or put that in a separate memorandum. Their bank accounts, if you already specify a beneficiary, you don't need to put that in a trust. There is a big difference between specifying beneficiaries versus trusts. With beneficiaries, when you pass away, they will get it everything in one lump sum right away, and you may feel that your children may not be ready to get a whole lump sum right away. If you have special needs kids, getting an inheritance outright like that may disqualify him from government assistance. Or if you have children under 18, that also won't work. So I have a video on, if you want to get deep into that, I have a video on why a trust sometimes is still useful, helpful to do, even if you can list beneficiaries. So not every items belong in a trust is the point of this. Great. Now let's talk about 3 ways to create your trust, okay? Not surprising, the first way is hiring an attorney. Depending on which state where you live, it could cost, $3,000 to $5,000. I live in Boston and my friends are getting quote of $7,000. It's definitely expensive, but if that's your only recourse, that's still better than going through probate. Another option, of course, is doing it yourself, which is a lot cheaper. And what most people wish is that they could do it themselves, but have an attorney to review, the final document so they can sleep better at night. It sounds like a great idea, but in reality, it's very, very difficult, if not impossible, to find attorneys who want to review documents. That's because they get paid more creating a new estate plan. They also use online platforms. They just input the parameters of the clients, and then it spits out an estate plan for them. That is so much quicker for them, and they get paid a lot more than being responsible for your document, reviewing it carefully line by line, understanding, how it works, and then advising you. So in reality, it's very difficult to find an attorney who is willing to review a third-party online platform, which is why I was really, really excited to find a company that is do-it-yourself, but also has attorney support. It's a guided do-it-yourself with attorney support. And let me explain to you how this works, okay? So it's a 3-stage process. First, the guided part is getting started. I find that it's a mistake to just jump directly onto an online platform without any preparation. You want to understand the basic concepts, like I just explained, about the big picture. Like, is it going to be a joint trust, an individual trust? What are the pros and cons? Do you want to, who are your beneficiaries? What ages? And what are the pros and cons of waiting versus giving to them outright? So there's a lot, I think, of planning questions. The more you do them, the more you'll be prepared. And these worksheets also help you go through the platform more accurately. So that's the first stage. It's just a way to get you more mentally prepared and understand what you're about to do. The second stage is Trust and Will, which is the company that has the attorney support. It's modern, it's intuitive, it's trusted by millions of families that have done trusts and wills with it. It is unlimited edits. You can go back online and edit as many times, unlike if you work with an attorney. If 2 years later your child got married or something, you would have to face another round of attorney fees. And it has phone support Monday through Friday, in addition to email and chat. It will also print out your entire estate plan binder for you, the first set at no charge. The most interesting part that they offer is this attorney support. What exactly is this attorney support? An attorney that's licensed in your area. You can call the attorney for line-by-line review, or if you have specific questions, if you're ready to transfer assets into your trust, the way you transfer a house deed into the trust is quite different from transferring a crypto account or from transferring a rental property. So these are questions that you can get attorney guidance on. Unlimited 30-minute calls with your attorney. So you get both, right? You get technical support by phone, email, or chat, and you also get legal support. Full disclosure here, the attorney support is currently not available for Alaska, Hawaii, Louisiana, Mississippi, Oregon, South Carolina, and Tennessee. Trust and Will is continuing to grow their networks, but as of right now, these states cannot offer the attorney support. So this is the plan that I really recommend because it's the DIY plus attorney support. You get the best of both worlds. The reason I partnered with Trust and Will is because it's the leading estate planning online platforms out there. They have over 1 million Americans that have created their plans with it. It is AARP's exclusive estate planning partner, as well as, these two other big establishments. So it's been around almost 10 years, and it's just it has a very strong reputation. The trust plan costs $600, and the attorney support is an additional $300. So all in all, it's $899 to get both the platform and the attorney. However, because of my partnership with them, for webinar attendees, you can save $200 off if you use this promo code, save 200. And there is a expiration date, Monday midnight. So you do have tomorrow and the weekend and Monday to think about it. And if you enter this promo code, you take off $200. That brings the package to $695. And I just want to make sure you understand what you get with it. The platform is included. The Trust and Will Unlimited access for a year is part of the package. And you also get local estate planning support, unlimited 30-minute calls. And sorry about that. And then you get complimentary printing of your estate plan documents. The complete estate plan documents you're getting is the living trust, the pour over will, the healthcare proxy, and the power of attorney. And they do a complimentary print and ship. So they'll print it and organize it in a nice folder and ship it to you. In addition to that, you also get the getting started resources, the videos. I actually create those. If you've looked at my videos, you know that I really love explaining things in plain English. And I feel that before you start on an online platform, it's so helpful to just get a preview of the decisions you'll be making in the platform and what the screens look like, so you'll feel more prepared. It's, as I said, 1 year unlimited edit phone email support with the Trust and Will customer support and a 30-day money-back guarantee. So if you find that it doesn't meet your needs or that it's too complicated, I've not had a single client say it's too complicated, then no questions asked, you get your full refund. The way you sign up is by going to livingtrustdone.com. If you go through trustandwill.com directly, you'll have to pay their website pricing, which is the 600 plus the 300, 605, which is $900. Yes. So the trust is 600, the attorney is 300, that's $900. Whereas if you go through my portal, livingtrustdone.com, and you put in the promo code, so when you type this, enter this domain name, you will be asked to make a selection of the DIY with attorney support, which is $695 after the discount. But you can choose to just do it, just the platform without attorney support. I don't recommend it because the attorney support is only like $250 more, and it's unlimited. I mean, that doesn't even pay for 1 hour of attorney, After you make your selection, don't forget to enter your promo code to get the discount. And then you will receive an email to get you started with the videos and the worksheets and the preparation you need. Do you have questions on this package or on any of the things I explain or anything that confused you? Time for questions.